one of the nation's finest psychiatrists and evaluators of people who are charged with crimes. He has evaluated you in a report dated February 22nd, 2023. He deems that you are competent to proceed with your case. There is no evidence of any active mental illness. So yes, this is Court's Exhibit 1. It will be made a part of the record without objection.
No objection, Your Honor.
And State?
No objection.
In each of these cases, we're going to take up 4 where you were charged with a state jail felony of evading arrest, and this is on or about May 10th, 2021. It's a state jail felony, and there are prior convictions that are alleged, which means you could be convicted of this state jail felony, but I believe the punishment could be up to a second-degree felony punishment, up to 20 years in prison. Yeah, you just have to understand. You were charged with illegal possession of phencyclidine, which is a terrible, evil thing on this planet. I wish phencyclidine would never have been found, but it is of the box, and it is an evil thing. But possession of it, illegal possession of it, is.
I'm sorry, Your Honor. Did you just threaten me? Did you just
hey,
make
no, wait,
a threat
wait, Laurie, right over there.
Mr.
Mr. Holmes, just listen to me and be quiet. Do you understand? I have ordered you to be quiet and listen. You were looking at a second-degree felony, and that you interrupted me again. This means if convicted, you face up to 20 years in prison.
Here the discussion shifts to competency, revealing a critical tension between clinical evaluation and courtroom behavior. Despite professional findings that the defendant is mentally competent, his conduct suggests manipulation rather than illness. This section highlights the court's dilemma: how to proceed fairly when a defendant weaponizes misbehavior. Lawyers express frustration, noting repeated refusal to communicate. The judge frames the behavior as strategic disruption, not incapacity.
20 years in prison. You also have prior convictions. If all of this were found true, you were looking, if convicted, no less than 25 years up to life in prison.
With a mental teeth feeling in my mouth.
You got anything else to say?
I don't.
You're going to get in timeout. You're in timeout just like a child until you can behave as an adult. Shame on you. You're held in contempt of court. Shame on you. Shame on you. Shame on you. Well, he's held, I know it. Well, that's one. But the expert says the man is competent, which leads us to believe that he has learned to manipulate the system.
Yeah.
And as long as he
said that he was going to hit you
acts unruly and threatens you, well, there's a way to do that. We'll just have to
I just want you to be aware.
bind him up.
The problem is it doesn't matter which attorney. It doesn't matter.
Yeah, well, I know, but
he's going to do this with every single attorney.
I know, and that's why
to continue representing him, but he just wants to understand.
I understand.
I'm not going to.
I understand the system and the rules are built for people so that the rules apply, not people who can just act like a child.
That's
and a temper tantrum as a child after he's been declared competent, clearly competent. He can't frustrate the proceedings. And if that were able to be done, then people would catch on pretty quickly of how they can manipulate the system. But anyway, what we'll do is we'll discuss later about how we might handle him. But if he's going to, there's have to bind him, but that's what I will have to do, and I'll tell him that's what will happen. There will be you muted, and you will be bound for the safety of everybody. Because
at this point, the defendant again interrupts, triggering another stern rebuke. The judge repeats the potential penalties to emphasize the gravity of the case, yet the defendant's hostility persists. The court interprets this as deliberate manipulation, a tactic to derail proceedings or gain advantage. This portion illustrates the escalating pattern: threats, contempt findings, and a judge forced to consider physical restraints simply to maintain decorum and ensure the process can continue.
Because the experts say you're really competent no matter what you want to do. And he's life in prison, which is not something anybody likes to have to think about, but
He's fitting next.
if you decide acting like a child in a temper tantrum of a child,
Yes.
then anything can happen. So it's built to handle that. And the only way to do it is act firmly.
Yeah.
That's what we've been trained to do, is when people
And
act like that, you don't let the little temper tantrum childlike behavior rule the courtroom. I think we have to set. People
Yes,
are
sir.
here to act responsibly as adults. And if you don't act, then there are methods that have to be dealt with. And
There are consequences.
and you just has to be made aware that it works against him, and it harms his future outcome in a case.
Yes, sir.
And it's this is another reason why you shouldn't use phencyclidine, because PCP makes you act strange sometimes. So anyway, we will
Thank you, Judge.
we will work on that, deal with it so that you feel safe, Lori. And
Well, and I just not that I don't feel safe. It's just, I'm not going to stand there and let him threaten me and nobody be aware of it. So he just has to understand that that's unacceptable.
yeah, and again, for the record, the defendant threatened his attorney to punch his attorney, and she had done nothing except attempt to help him in a polite way. But the man is also appears to be doing whatever he can to make not only himself the center of attention, but also to frustrate the proceedings. And that is what we'll do is we'll bring him back a little later, and I'll talk to him.
The judge now outlines the consequences of continued misconduct: binding, muting, and firm procedural control. The tone becomes instructional, almost parental, stressing that tantrums will not dictate justice. The discussion expands to the broader risk. Allowing disorder would encourage others to mimic such tactics. The judge reinforces personal responsibility, warning that this behavior directly harms the defendant's outcome, while reaffirming that competency means accountability, not leniency.
Do you want me to wait here, or do you want to?
No, you can go,
Okay.
because
Just let me know if I need
I've got to
to
deal with him in his contemptible behavior.